Hi, my name is Lynne Strober. I am a partner at Mandelbaum Barrett, and I co-chair the matrimonial and family law practice group at the firm. I've been here for quite a while. Today I'm going to discuss what happens when there is a mental health issue with a client or a child during a divorce proceeding. As we look around, there are mental health problems and issues everywhere. There are drug abuse problems and behavior problems. Divorce is one of the most stressful life events. Adding to that, if you have a child with mental health issues, or even if you or your spouse or partner have mental health issues, that makes the entire process much more difficult and elevates the stress. Mental health problems raise multiple issues. It can be raised within a custody case. It can be raised in terms of a party having problems where a child, is the parent able to visit with the child? Is the child comfortable during time sharing? Is the parent having a negative effect on the child? Is the parent getting help trying to deal with the situation? Is the child getting help during the divorce process? A court can order, where necessary, alcohol and drug assessments, mental health assessments, including a custody evaluation, and can have psychologists and psychiatrists evaluate both parties. The treating doctors may get involved, and you can have issues with regard to the access to mental health records because of HIPAA laws, and whether the other side is able to see those medical records. And the standard is to try to avoid that and come up with a way of getting the information without being too invasive. So there is a lot of work that needs to be done in addressing these issues. The parties are sometimes referred to DCP&P, the Division of Protection and Permanency, that addresses family dynamics when they rise to a level of concern. DCP&P can be brought in by the court. They can be brought in by a referral. Parties have been known to refer each other to DCP&P, or a neighbor or a school teacher can refer, or any other person. These cases can last for quite a while. If the child has issues, the court can require that they receive treatment. If the children's needs are not met, the court will review a custody determination and may restrict a party's sharing, time sharing with the child if it causes a risk or danger to the child. From an employment perspective, does the mental health problem interfere with a party's ability to obtain employment and therefore affects alimony, as to the payor or as to the recipient? And a party can wind up being evaluated by medical health doctors and employability experts as part of a case. As the case heats up, sometimes behaviors become more extreme because of the stress of the divorce. You're living in the house with the very person you don't want to have around you, so it can be very difficult. And there can be hostility in the house. The police may be called. We may wind up with domestic violence allegations and hearings. And is additional treatment necessary? Does a party need to be hospitalized? Is there violence? What do we do with the children? And it's very difficult to remove a party from the house without domestic violence. So you may be stuck in the house together. It is in the family's best interest to keep the situation as calm as possible. It is best if the parties can work towards settlement, but that's not always possible. The parties may end up going back to court repeatedly to address custody issues and problems. Do one of the parties have a relation, or the parties separated, and do one of the parties have a relationship with somebody that has mental health issues? And now does that become a part of the case? Because a court wants to most of all protect the children and make sure that they're not in jeopardy. And again, there can be problems of drugs, alcohol, medical issues. A court can test parties. A court can, for alcohol, for drug abuse, a court can require that a party participate in a 12-step program. There can be further assessments, parameters on a party's ability to see a child. A party can be required to prove that they have received help before they see a child. If somebody has DUIs, you can't have them driving a child. So the situation just escalates and escalates. And the court needs to do the best that it can to protect the children. Sometimes courts will appoint a parent coordinator to be involved to help monitor the day-to-day activities. The court can put a mediator, sometimes the parties can put a mediator in place to work on more global issues. Therapy can be ordered for an individual or for the family. A party can have physical problems as well as emotional problems that cause depression, anxiety, and anger. And that also adds to the problems that the attorney and the parties have to deal with during the divorce. Custody could be challenged if mental health becomes an issue. And there, again, it's hard to stop the case from being returned to court because the court doesn't want anything to happen to the family. The court wants to make sure that the case proceeds in the best way possible. Courts can appoint a guardian ad litem for a child so that the child has additional protection. That guardian ad litem will conduct an investigation and report to the court. A court can appoint a guardian for a child if a court feels that the child needs a separate lawyer. A guardian can be appointed for a party if a party can't make decisions on their own behalf, either on a limited basis or on an extended basis if the party can't handle money, can't handle issues, and again, the situation escalates. So cases like this are clearly very difficult to handle. They require a combination of strength, compassion, caring, patience, and good guidance. There's a lot to deal with, and I suggest a very knowledgeable attorney will be very helpful.